Welcome, everyone. I'd like to welcome you to Trademark Abilities Insider. My name is Stacy Calamaris, and I'm an attorney and the lead instructor at Trademark Abilities. Trademark Abilities is a comprehensive online training academy for lawyers interested in learning the practical aspects of practicing trademark law at the USPTO and becoming confident trademark practitioners. Through our signature masterclass, we provide the practical and strategic learning necessary to set up a trademark practice so that lawyers can confidently and effectively represent clients before the USPTO. Our templates and other resources have been described by our attorneys as a trademark practice in a box. I want to welcome you, Jason, to the inaugural episode of Trademark Abilities Insider.
Well, thanks for having me.
Thank you so much for being here. Through this series, it is my intention to interview people like you who have insider knowledge that helps make the life of the trademark practitioner a bit easier. And with that, I'd like to turn it over to you to please tell us a little bit about yourself.
Well, thanks, Stacy. It's an honor to be your first guest, and I hope it'll be entertaining and fun. I'm looking forward to it. Yeah, my name is Jason Blair. I'm currently a trademark attorney at Fleckman McGlynn in Austin, Texas. Prior to my tenure here, I was a trademark examining attorney at the U.S. Patent and Trademark Office from 2005 to 2018. So I was there 13 years, and most of that time, in addition to being an examining attorney, I was also the head of the sound and motion mark examination for the USPTO. I got that kind of off the ground and running for the agency. So it kind of explains my longer than usual tenure there. So it's great to hear, you want someone with insider knowledge. I don't know if I have insider knowledge, but I'll try to give you what I got.
More than I do, for sure. Well, that's awesome. Well, I'm so delighted to have you. And so can you tell me a little bit more about the USPTO's process of how applications are assigned to examiners? I think we as trademark attorneys think that it's a very sort of cloak and dagger process. So, and it probably isn't. So,
it's really kind of just the server. You go up. You have your docket there as an examining attorney. There's your new application docket, and whenever you feel like you're ready for one, you just click Get File, and the server pulls the next one up in line for you. If there is a situation where the same applicant has filed more than one application, I think in a 3-month span, then it will give you all of those applications up to 10. It won't give you any more than 10. So it's really just sort of the next one up. You don't know what you're going to get. It's kind of like playing the old game show. You say no whammies, and then you hit the button.
That show, actually.
So
press your luck.
Yeah, press your luck, right. So you hope it's a good one. You always hope for what we call a first action pub. I assume we use that on the outside, but pub is just what you refer to as approving a mark for publication. And then you hope that it's not a paper application anymore. Those are pretty rare, but those were always hard because T's was great that, all the boxes are right there. A paper application, you have to sort of go through. And so that's really the process of it. It's not really anything where we have the, ability to choose even what type of field. I think there is a misunderstanding that, on the patent side, there are art units and I know some patent examiners that just deal with, ceramic coatings for engines or something. I mean, you don't know what class it's going to be in. Okay. You all go from furniture in one application.
Nothing nefarious. It's random, except for that same applicant within a certain period of time.
Right. And the system will only look for it to be exactly the same. So sometimes you'll have like a comma in the name, or
if they're related entities, then those may not come to you from a consistency point of view.
The system is just looking for exact name matches. Yep. So sometimes if you put LTD at the end of one and you put limited at the end of the other, the system's going to see those as separate. You can kind of if you look through it in your search and you find them, then you can manually pull them into your docket. But when you click it, it just automatically comes in. There's no there's no magic behind it that I know of.
No, I think that's good to know. So I think not all private practice attorneys may not be aware that trademark examiners also have time constraints by which they're required to do their jobs and spend on each application. Can you give us a little bit of an insider's perspective of what happens after the application is assigned to you? So in other words, how long do you have to either approve that application or issue an office action? And then my follow-up question would be, does that mean that you just issue an office action because maybe you are under a time constraint?
Well, the time constraint is not per application per se. Our time constraints are on a quarterly basis. So you have a quarterly number of, we call them points. So you get a point for each class when you take a first action on an application, and then also when you take a final disposition of that application. So when the first action goes out, if it's a one class application, you get 1 point for that. And then you'll get another point when the application either abandons or it's approved for pub. Okay. A multi-class application, if there's 4 classes, you issue a first office action, you'll get 4 points for that. So you have a certain number of points.
Or 4 points if you approved it for pub.
Well, you'd get 8 then if it was a 4-class application. So because you'd get the 4 points for taking a first action on it, and you'd also get 4 points for the final disposition. So
wait,
there's really,
I just want to make sure I understand.
Yeah.
So if you didn't issue an office action on the 4 class, but you just approved it for pub, would you get 4 points or 8 points?
You get 8 points. You get 8 points.
Interesting. So you are incentivized to approve something for pub, not to issue office action.
Yes. The best thing that you want, I think there's a misunderstanding that examiners love refusing applications.
Yes, I think there is.
No, you want to approve everything. The easiest thing in the world is you get an application, you look at it, you click a button that says approve for pub.
Fascinating.
Because that is
get more points.
If it's a 1-class application, you get 2 points and you didn't have to write anything. You click a button.
And it's more efficient because you get more points, it's more efficient, and everyone's going to be happier.
Yes. So, you want to do that. The thing that you don't want to do is do that, and then the quality review people, we call them TQR, Office of Trademark Quality Review, randomly pulls files, and you only have a certain number of errors that they can find on you per year, or you will lose all your bonus. If you're very egregious, you could theoretically, just get put on probation and stuff like that if you're really bad.
So you need to work properly, efficiently, quickly, but accurately as well, I think.
Yes. So that's the concern for accuracy. And so basically you have a certain number that you have to do in a quarter. You have to get so many points. Okay. And if you break that down on a per application basis, if you're working an 8-hour day, you need to get probably 6 to 7 done in any given day in a quarter. So the thing is, if you break that down, that's probably about 45 minutes to an hour you can spend on each application. But that's assuming that, they're all the same. And that's the thing is they're not.
So a follow-up question to that with regards to when private practitioners submit responses to office action, when those come back in from outside counsel, is there some sort of guideline that you all have in terms of how quickly you need to review those to get either a second action out or either approve it for pub or either a second or final action back out to us?
If it's just a small, I'm not sure what all the issues they are. Sometimes the system will put it right back in my docket as an examiner if there's, I think, very minor changes. But most of the time it goes through the paralegals at the USPTO, which are called, I don't know why they call them this. They're called legal instrument examiners, and they're LIEs.
Oh, yeah, I see that a lot in the TSDR, LIEs.
Yeah.
Okay.
Funny story. I actually had an attorney come up to me and they said, well, "What is lie processing? Are you checking our applications for lying?" Or they thought it was like making sure that they were cross-referencing that we're you're signing the verification that it's truthful. And I was like, I didn't even know what he's talking about. And I'm like, oh no, it just means the paralegal's checking it. That's what it is. An LIE is a paralegal at the PTO. Okay. So I actually had a conversation the other day. Normally they would probably take about 72 hours to have those back on the examining attorney's docket. Currently with the backlog at the PTO, all of the manpower is being thrown at examination because the two major things that Congress looks at to see how effective the USPTO is their pendency on first actions and their pendency on final dispositions. So that's where they're throwing all of their manpower at right now. And what's really suffering is sort of the back end stuff like the LIE processing, assignments, renewals. It's just because those aren't really measured so much by Congress. So I've been told that it can take up to 30 days now sometimes for paralegals to process these and get them back on the examiner's docket.
And that's a long time.
It is a very long time. And I think it does run...
Once a response is submitted.
Yes, and that could run into issues like if you're responding, through a request for reconsideration and you've got an appeal deadline coming up and you want to see how the examiner is going to respond before filing that appeal, that's going to be a problem because they're probably not going to see it right now with the backlog. A few of my friends have said, just sometimes if you think the examiner is going to approve it, call the examiner and say, hey, look, I filed a response here because I can manually go and put it back in my docket, sort of override the paralegal. But I'm just not aware it's there until it shows up in my docket. So that's something that I would probably, it might be a good tip, just to get it. Now, once it's in your docket, you've got 14 days to issue an action. So to either issue a final or whatever you're going to do with it. And you can also, once again, request some extension from your manager. I think your manager has the discretion to give you another 7 days if it's really a hairy application. So, but that's kind of the deadline. I would say in a normal time, if you file a response, it would probably be on the examiner's desk in 2 to 3 days. They would have 14 days to act on it. But right now, they're probably not getting them for almost a month. And then they still have the 14 days to act on it. So
interesting.
Sort of odd times, yeah.
Yeah. So that brings up another interesting question. So what do you think, you just mentioned that in that instance, right, and with the backlog, it might be a good idea, especially if you have something another deadline pending to call the examiner. What do you think are some other tips that you think practitioners could do to help move along their clients' applications? Where they could be helpful instead of some things that they do where you and I both know they're not so helpful.
Yeah, as far as kind of, I guess, getting on an examiner's good side, they're under time constraints. And so I think at least for a first action, one thing that was always sort of a pet peeve for me were responses that I would get that were almost like they're teeing up for federal court litigation. Like it's just like they're defining the parties and there's like headers and, plaintiff hereby, applicant. And it's like, it shouldn't really be that formal. It's just going to take a lot of time for me to go through this. I'm not really looking at it to the level of, okay, what's the evidentiary record, at least on a first action response, you know? So what I do as an examiner, and how we would mainly talk about it with managing attorneys, senior attorneys, you know, if we're sort of spitballing on should we maintain this refusal or not, you're sort of just distilling it down to the basic arguments. So, you know, don't fill it up with a lot of fluff. You don't need 30 different types of evidence. You know, just really pithy and to the point is going to get you, I think, in better graces for with that examiner. Now, I understand if you're responding to a final, you got to get your evidentiary record you know, up to snuff in case this goes to the board and they're going to, you know, look at it more formally. There's one of two things that I would get with applicants is they would either assume I'm an idiot or they would assume I'm a total expert in the field. And I'm sort of neither one of those things. 'Cause a lot of times you sort of know when you're issuing a likelihood of confusion refusal, you know what the applicant does, and you really know what the cited registrant does. Sometimes.
Maybe. It depends.
Maybe.
You may not if it's an ITU. Right.
But, you know, you have to look at the ID in the registration. So sometimes, like, you know, you get these sites and then applicants' attorneys would call you and you'd be like, you know, how do you not know that they only make this type of jewelry and we make this type of jewelry and they're totally different? I'm like, I understand that, but their ID just says jewelry. So I have to presume that it's all types of jewelry. And it doesn't matter how much market evidence you show me. I cannot look at that. I have to look at the face of the registration. And they would just, you know, sort of call you, you know, blah, blah, blah name, and how can you be so dumb? And I'm like, would you say that to a TTAB judge? Would you say that to, you know, to an actual judge? You know, I mean, you know, we're not judges, but we're still sort of in that position in a way. We're trying to help you. But sometimes there are things where I want to advise a client, but you can't advise an applicant to say, you know, maybe if you limited your ID, or maybe if you sort of focused on this argument, I would be, but you can't put that in an office action. Right. So sometimes just calling, kind of seeing if they're open to that, you can sort of sometimes distill what really is their issue with this ID. And then on the flip side of that, I would have clients that just, they would assume I know every single thing about this industry. Like, you know, you'd have some applicant, it was like a gas and oil drilling stuff. And then you cite another mark that's almost the same and it's gas and oil, and they call and they're just like, well, we make diamond studded tips for drill bits that only go down to 2,000 feet. And this other company does, you know, oil pumping, whatever. And they're going to use Halliburton and we're going to use Chevron. And you're just like, okay, look, I'm not an industry insider where I know every single thing about the logistics of oil drilling. Right. You know, please explain it to me, but you don't have to, like, you know, be so.
That's your job to explain.
Yeah. So I mean, that's all case specific, but exactly. You know, we're really here. I mean, to be, you know, as much in the customer service field as we can, without sort of crossing that line into sort of advising you. And that's the thing, is you sometimes want to give an applicant advice, but you sort of are limited by doing that. So yeah.
I mean, I think there's two extremes, right? To the point you just made. I mean, being pithy and to the point, okay, maybe, but not a response that says the marks are not likely to be confused because they're not likely to be confused.
Right.
So, I mean, we all went to law school. We all know how to write a brief. So write it, maybe, you know, 5, 6, 9 pages. But on the other extreme, maybe not 1,000-page office action response, right?
Yeah. Those are garbage. You're going to not have the time to read through that. It's not something where, I do think that a lot of people in the field and the private practice now that, we're on a flat fee model, but when it comes to responding to office actions, it kicks back to that hourly model. Well, an examiner, if you think about it with their time constraints, they're still kind of on that flat fee model in a way. It's not something where if you send, it's not like sending deposition and discovery requests and there's 1,000 pages, I can sit there as an examiner and read all 1,000 pages. I'm going to have to say, man, I've got 45 minutes to cut through this and get something out. So you're probably going to just scan it. And then that's when you get the applicant's attorney calling back and saying, well, obviously you didn't see my argument to that on page 320, third paragraph. And I'm like, no, I didn't actually see that on page 320, third paragraph, because it's way too long and I'm not going to read it all.
I really think we should institute the same types of rules that we have at the board, right? If you can't say it in 25 pages, then you can't say it, period.
Right. Yeah.
In the rarest of cases, right? Like,
yeah.
I mean, there might be some exhibit, right? You might have to do survey evidence. I mean, very, very rare cases would you need to go beyond that. But I mean, I see some, really interesting responses where, people who don't know what they're doing are submitting, voluminous responses and, declarations of themselves attesting to ridiculous things. So it's just really, really crazy. So last question. So, you spent the majority of your career working with sound and motion marks. You got this, division off the ground. Briefly, right? Because I'm sure we could do a whole session just on this. What are some special tips, right, that practitioners should pay attention to if those are the marks that they're applying for their clients? Because they're a little bit different.
Right. I would say for any non-traditional mark, whether it's sound, whether it's motion, whether it's product packaging, examiners don't see those a lot, and there are specific examiners for certain types of non-traditional marks that we try to get those to the right people because they've got a little more experience with them, but not all of them do because people just don't, I think, read the rules on how to apply. So you'll get a sound mark and someone's like, well, I don't know where to put it. Where do I put it in the application? So you'll get like a standard character mark, but the standard character the mark is the sound of a bird chirping, but it's in the standard character field. And I don't know why, but this would happen all the time. We would be on the lookout for those, but they would sort of slip under the radar. And they would land in the hands of a normal examiner. And you'd think that the normal examiner, like a light bulb would go off in their head, like, okay, this says in the standard character field, the mark is the sound of a bird. Maybe this is a sound mark. But for some reason, that light bulb never goes off. And then all of a sudden you end up with a registration for the standard character words. The mark is the sound of a bird. Like visually, and you're just like, okay, now we're kind of in trouble. So I would say that if you've ever had a sound mark before or any kind of non-traditional mark, you could sometimes call the examiners and let them know, hey, I'm thinking of applying for this. What do I need to do to attach it? Anybody out there, give me a call. I will help you out with some of the technical issues, just because really that was my big concern. When I started at the PTO, I thought, well, what are the legal ramifications of implementing all this stuff? And really what the problem was the technical limitations at the PTO, the server capacity, how the system's going to process, audio and visual files and
itself.
Yeah, the IT stuff was really kind of the problem, sort of shoehorning that into the T's system. So there are a lot of things that you can't sort of be too overly careful. Even if you're unsure, put it in the miscellaneous statement mark. Like, this is a non-traditional mark I'm applying for. I didn't know where to put the drawing or the description. And, they would, at least the examiner would see that. So if it lands sort of in the wrong examiner's hands, there's enough flags to go off that, okay, I need to run this up the flagpole and maybe get it routed to the right person.
I thank you so much for your time. It was really awesome chatting with you and getting your insider point of view. So thanks so much for joining us.
Thanks for having me. I appreciate it.
Absolutely.